she says when he leapt into her arms to greet her at the party, he broke her wrist.
But when stuff like this happens and it hurts me and it could potentially hurt other people.
Filed by a black former Northwestern University PhD student who said he was the victim of police brutality.
54-year-old aunt who went to her nephew's 8th birthday party is suing the boy who's now 12.
It's not easy for me to be put back into that situation and have to relive it again.
Spilled some in her lap and got paid millions of dollars. The problem is just about all of those simple facts.
Third-degree burn or a full-thickness burn means that the entire layer of skin is burnt through, is gone.
Number 4, Liebeck versus McDonald's. Stella Mae Liebeck, a 79-year-old woman, ordered a 49-cent cup of coffee from a McDonald's drive-thru in Albuquerque, New Mexico on February 27, 1992. She spilled the entire cup of coffee on her lap while attempting to add cream and sugar to her drink in her nephew's parked car, which did not have cup holders.
I'm going to reduce the punitive damages award to $480,000.
But when stuff like this happens and it hurts me and it could potentially hurt other people.
The printout of all the burns that had occurred in roughly the 10-year period preceding this, some 700 burns.
The coffee scalded her thighs, buttocks, and groin, causing third-degree burns on 6% of her skin and lesser burns on 16%. She was taken to the hospital, where she underwent skin grafting and remained for 8 days, losing almost 20% of her body weight during her stay. Liebeck suffered permanent disfigurement and was partially disabled for 2 years after the incident. Liebeck sought to settle with McDonald's for $20,000 to cover expenses, but McDonald's only offered $800. She retained an attorney and filed a lawsuit in the U.S. District Court for the District of New Mexico, accusing McDonald's of gross negligence. During the trial, Liebeck's attorneys argued that McDonald's coffee was unreasonably dangerous and defectively manufactured, as it was required to be held at 180 to 190 degrees Fahrenheit, much higher than the 140 degrees Fahrenheit temperature they believed it should be served at. They also presented evidence that other establishments served coffee at a substantially lower temperature than McDonald's.
When I saw the amount of skin that was burnt, I was pretty surprised. And
until just about all anyone remembers was a woman was driving down the road with a cup of McDonald's coffee.
Can I help you?
Yes, please. Can I have a small cup of coffee?
Third-degree burn or a full-thickness burn means that the entire layer of skin is burnt through, is gone.
$2.9 million to a woman scalded by a cup of McDonald's coffee.
The jury was presented with expert testimony that 190-degree Fahrenheit coffee could produce third-degree burns in about 3 seconds, and 180-degree Fahrenheit coffee in about 12 to 15 seconds. Liebeck's attorneys argued that lowering the temperature to 160 could provide adequate time to remove the coffee from exposed skin, preventing many burns. McDonald's claimed that the high temperature was necessary as their customers were typically commuters who wanted to keep their coffee hot during the trip. However, it was revealed that McDonald's had carried out research showing that their customers intended to consume the coffee immediately while driving. Other documents obtained from McDonald's showed that from 1982 to 1992, the company had received more than 700 reports of people burned by their coffee and had settled claims for over $500,000. Despite this, McDonald's quality control manager testified that this number of injuries was insufficient to cause the company to evaluate its practices. The trial lasted from August 8 to 17, 1994, before New Mexico District Court Judge Robert H. Scott. The jury found McDonald's 80% responsible for the incident and awarded Liebeck $160,000 in compensatory damages, which was reduced to $640,000. McDonald's ultimately settled with Liebeck for an undisclosed amount before the appeal.
That story to me is tying up the court system for a bunch of nonsense.
Spilled some in her lap and got paid millions of dollars. The problem is just about all of those simple facts.
Seeing an old grandma started screaming, I looked over and I noticed the coffee cup had tilted over.
And then I realized that this was something a little more serious than usual.
Number 3, Bigby versus phone company. Charles Bigby was standing in a phone booth when a car struck him. He sued the Pacific Telephone and Telegraph Company, arguing that the company was negligent for placing the phone booth so close to a busy roadway where drivers would speed. The company, on the other hand, argued that they had no duty of care to Bigby because there was no way to foresee a car leaving the roadway and striking the phone booth while a person was inside. The court granted the company's motion to dismiss, but Bigby wasn't going down without a fight. He appealed the decision, arguing that the determination of whether there was a foreseeable harm was a question for the trier of fact. Fast traffic and inebriated drivers are expected on the roadways. It is foreseeable that these drivers might lose control of their vehicles and crash into objects near the street. Based on these facts, a jury could reasonably determine that a car crashing into the phone booth was a foreseeable harm because the phone booth was placed so close to the street without proper protection. The court agreed with Bigby, ruling that the question of whether the harm was foreseeable should have been a question for the jury. A trial court had erred in granting summary judgment for the defendant, and the issue was reversed and remanded. But the majority of the court was wrong in determining that foreseeability could not be decided as a matter of law in this case. In fact, in determining the foreseeability of a risk of harm, several factors must be weighed to establish if the telephone company owed a duty of care to Bigby. There are cases where there is no duty to Bigby for some foreseeable risks. In this case, however, the risk of harm to pedestrians who use the phone booth was a foreseeable harm of vehicle traffic. Placing the phone booth 15 feet away from the curb was safer than placing the booth on the sidewalk. Phone booths have a history of being placed next to streets and highways for the convenience of the public. Negligence liability is only imposed when the risk of harm is unreasonable. In this case, the benefits of having the phone booth in its location outweighed the foreseeable risks. Therefore, the Pacific Telephone and Telegraph Company was not negligent in placing the phone booth where it was. In conclusion, while the court ruled in favor of Bigby, it's important to consider all the factors when determining if a company owes a duty of care to its customers. In this case, the benefits of having the phone booth where it was outweighed the foreseeable risks, and therefore, the company was not negligent. Number 2. He stole his own car. Dr. Lawrence Crosby, an engineering graduate student at Northwestern University, was driving his own car in Evanston, Illinois, when he was stopped by police in 2015. A woman had reported a black man stealing a car, and police responded to the call. When they saw Dr. Crosby driving his car, they pulled him over, dragged him out of his car, and arrested him, even though he had provided proof that the car belonged to him. Dr. Crosby was handcuffed, put in a squad car, and taken to the police station, where he was held for 45 minutes before being released without charges. During the incident, the police officers had used excessive force, roughed him up, and refused to listen to him when he told them the car was his.
Filed by a black former Northwestern University PhD student who said he was the victim of police brutality.
On the ground, on the ground! My goal is to try to use the voice that I have to bring awareness to this issue. It's not easy for me to be put back into that situation and have to relive it again.
Dr. Crosby, who is black, later sued the city of Evanston and several police officers for excessive force, false arrest, and racial discrimination. The lawsuit alleged that the police officers used excessive force, roughed him up, and refused to listen to him when he told them the car was his. The lawsuit also claimed that the incident was racially motivated. During the trial, video footage from the police dashboard camera was played, which showed the officers pulling Dr. Crosby from his car, throwing him to the ground and handcuffing him. The video also showed Dr. Crosby repeatedly telling the officers that the car was his and that he had the keys and the registration to prove it. The trial revealed that the incident was racially motivated. One of the officers involved in the incident, Sergeant Dennis Leaks, had told his colleagues over the radio that the suspect was a black male who looks like he's trying to break into the car. However, the video footage showed Dr. Crosby unlocking the car with the key and getting into the driver's seat.
How can you actively resist if you're on your back and officers are pulling you in different directions?
Does see is police officers coming out of their vehicles with drawn weapons. He puts his hand up in a universal surrender position.
Police department, which is trying to, again, portray him in a negative light, which is completely unnecessary.
In 2018, a federal jury found that Dr. Crosby's civil rights had been violated by the police officers and awarded him $1.25 million in damages. The jury found that the police officers had no reason to suspect Dr. Crosby of any wrongdoing, and that they had used excessive force when they pulled him out of his car and arrested him. The verdict in Dr. Crosby's case was a victory for those who have been subjected to racial profiling and police misconduct.
The experience that I went through...
That's a settlement. Is it justice?
No, it's not justice. I've had to deal with post-traumatic stress, make it through to the end of the night, facing however many weapons pointed at me, at least 6 guns pointed at me.
Number 1, how dare you hug me? In 2015, Jennifer Connell, a woman from New York, made headlines when she sued her nephew, Sean Taralla, for $127,000 over a broken wrist.
I don't know this woman's situation. Maybe she doesn't have health insurance and she had to go out of pocket, but why name the child?
I was informed that Sean had to be named. I was never comfortable with that.
She says when he leapt into her arms to greet her at the party, he broke her wrist.
The incident occurred at a birthday party in 2011, when Sean was just 8 years old. According to Connell, Sean had jumped into her arms, causing her to fall and break her wrist. Connell claimed that Sean was negligent and had caused her to suffer significant pain and suffering, as well as lost earnings and medical bills. In the lawsuit, she alleged that Sean had acted unreasonably and had failed to properly use his arms when he jumped into her arms. The lawsuit was widely criticized, with many people questioning Connell's decision to sue her own nephew. Some saw it as an example of the litigious nature of American society, while others felt that it was an unfair burden to place on a young child. The case went to trial in October 2015, and during the trial, Connell testified that she loved her nephew and that the lawsuit was not about money, but about holding him accountable for his actions.
The little boy who's 12 now is the only defendant. She's seeking $127,000. 54-year-old aunt who went to her nephew's 8th birthday party is suing the boy who's now 12.
Sean, what do you want people to know about your aunt?
That I love her and she loves me.
She claimed that the injury had caused her significant pain and had made it difficult for her to perform daily tasks. However, during the trial, Sean's mother testified that Connell had always been a loving and supportive aunt, and that the incident was simply an accident. She argued that Connell had not been injured as badly as she claimed, and that the lawsuit was unwarranted. In the end, the jury sided with Sean and his family, and Connell's lawsuit was dismissed. The judge in the case told the jurors that the case was not about bad people, but rather two people who loved each other, and that they needed to make a decision based on the facts of the case. After the trial, Connell released a statement saying that she was devastated by the outcome and that she had never wanted to hurt her nephew. That's all for this video, folks. We'll see you next time.